So now they are deporting American citizen toddlers with cancer. I don't know which of those three things is the most horrific. And I'm not kidding, there were reports that the Trump administration has now deported at least 3 children ages 2, 4, and 7 who are US citizens, and at least one of whom was receiving cancer treatment. So by now you know they're trying to rendition immigrants off to a foreign gulag in El Salvador without a hearing or a trial. But it looks like they are now trying to send American citizens away next. And I have to admit, before I looked into it, I didn't know what, if anything, could prevent that. I mean, we have private prisons in the US, so what, if anything, would prevent the US government from simply offshoring all of our prisons to foreign nations and sending citizens away? Well, thankfully, it turns out a lot. Now, in recent weeks, we've watched the Trump administration whisk people off for indefinite stays in Salvadoran torture prisons with absolutely no due process rights, no hearings, no jury findings, and not even notice of any criminal or immigration violations. And a lot of people have looked at that situation, shrugged, and said they're not worried because the people that the Trump administration is sending off to torture prison are undocumented immigrants, not citizens, and nothing like that could ever happen to a U.S. citizen.
What about Americans he would do? And you talk about me listening to the senator literally to represent him. It seems to me that these Democrats are representing.
But the thing about abusive government regimes is that they usually start off by persecuting the marginalized people first. They test out some rights violations on immigrants and minorities, and they rarely stop there. And you can tell your misinformed uncle who got his law degree from Twitter University that the US Constitution applies to immigrants as well. And they too are entitled to due process. But eventually abusive regimes move on to persecuting everyone. And following up on that playbook, Trump has now personally indicated that he wants to send, quote, homegrown criminals to Salvadoran torture prisons as well.
We also have homegrown criminals that push people into subways, that hit elderly ladies on the back of the head with a baseball bat when they're not looking, that are absolute monsters. I'd like to include them in the group of people to get them out of the country.
President Trump's press secretary has confirmed this aspiration, and he's asked his Attorney General Pam Bondi to study this question as well.
We're studying the laws right now. Pam is studying. If we can do that, that's good.
Well, Pam, you can take the weekend off because I've done your homework for you. And I've concluded that this idea violates a couple of constitutional provisions and a whole bunch of laws. Not that I think that will stop you. But first things first, can the Trump administration send Americans away without holding criminal trials? Definitely not. Now, we've already spent several videos going in depth about the Trump administration's non-legal actions towards immigrants. The short version is that ICE has been picking people up off the streets and off campuses and violating their constitutional rights by whisking them away to detention centers, often without even informing them about the justification for their detention, nor charging them with any crime. In retaliation for his First Amendment protected speech, Khalil Mahmood, a Columbia University protester on a lawful student visa, was picked up by plainclothes police officers in his campus housing apartment building and then spirited away to detention centers in New York, then New Jersey, and then finally Louisiana, where the Trump administration did their best to keep him from being able to reach his attorney or his family. Other immigrants like Kilmar Abrego Garcia have been picked up, shuffled around detention centers, and then put on planes, and then sent for indefinite prison terms in an El Salvadorian gulag without ever receiving a hearing or having a chance to get the assistance of an attorney, a violation of both their Fifth Amendment due process rights and their rights under the Immigration and Nationality Act. And even more disturbingly, we learned last week that the Trump administration has deported 3 children who were US citizens. The youngest child, who was only 2 years old and was born in New Orleans, was picked up with her mother when her mother went to her scheduled regular check-in with immigration officials. Despite the fact that the mother showed up dutifully to that appointment, ICE detained her, then deported both her and her daughter to Honduras. The Trump administration claimed that the child's mother wanted the child to be sent away with her, but there was never a hearing to establish this or time for the mother to adequately discuss the issue with the child's father, who says that he did not want the child to be sent to Honduras with her mother. And on April 25th, the judge in the child's case issued a blistering rebuke against the Trump administration, proclaiming, quote, "Of course it is illegal and unconstitutional to detain for deportation or recommend deportation of a U.S. citizen." Judge Terry Dowdy, United States District Court judge for the Western District of Louisiana, said it appeared as though the government had just, quote, "deported a U.S. citizen with no meaningful process." On top of that, 2 more children, 4 and 7 years old, were also deported with their pregnant mother after she was picked up at a regularly scheduled immigration check-in. Both children are citizens, and one of them has cancer and was undergoing treatment. The mother's attorney repeatedly tried to reach her after she was picked up, but ICE blocked her access and put the family on a plane to Honduras within 24 hours of detaining them. Now, it is possible, as the Trump administration suggests, that the parents who are removable may elect to take their minor children with them, but it could create a weird situation where the child could return to the United States whenever they wanted, but the parents could not. But all the more reason to make sure that the parents get the regular process, which looked like it didn't happen in these cases. We'll talk about that more. And as we've discussed before, in the immigration context, immigrants still retain due process rights in the criminal justice system, but in an immigration context, they also are entitled to a parallel specialized system created by the Immigration and Nationality Act, which governs the immigration system and generally requires notice of the government's intended action, opportunity for the immigrant to rebut the evidence, and an opportunity to be represented by counsel. Though the Trump administration has been treating these rights as optional and has been getting schooled by the courts for skirting the usual processes. But it's clear that the administration intends to keep testing the limits and try and get away with whatever it can get away with. Now, there is good reason to believe that the Trump administration has infringed on the constitutional rights of the immigrant detainees. But the protections for citizens are likely even stronger. American citizens are entitled to due process under both the 5th and 14th Amendment. These amendments cover the same rights, but the 5th Amendment due process protections apply to actions by the federal government, and the 14th Amendment due process protections apply to actions by state governments. Now, the 5th Amendment requires that no person should be, quote, deprived of life, liberty, or property without due process of law. The 14th Amendment language mirrors this, stating that, quote, nor shall any state deprive any person of life, liberty, or property without due process of law. Now, due process includes two buckets of things: procedural due process rights and substantive due process rights. Substantive due process focuses on protecting from government infringement on a broad set of fundamental rights, such as the right to marry, the right to privacy, to have a job. Though, full disclosure, substantive due process rights have been curtailed quite a bit by this particular Supreme Court. But procedural due process focuses on specific procedures that the government must follow before taking away someone's liberty or property. And procedural due process is the stuff of Law and Order episodes, the Miranda warnings, trial, evidentiary rules, and a jury system that we're all familiar with. But due process rights can be triggered by a wide variety of life, liberty, and property interests, not just by imprisonment as part of a criminal justice matter. Due process rights apply when the government terminates a benefit or issues a fine or hands down a monetary civil judgment against a person. And there are different standards regarding what constitutes due process in civil and criminal matters. Now, for the purposes of this video, I'm going to focus on the procedural due process rights in criminal matters, because the criminal justice system seems to be what Trump is talking about when he's talking about homegrowns. Now, at a minimum, in criminal matters, people are entitled to notice of the charges against them, an opportunity to be heard, and an impartial tribunal. A party must generally be given an opportunity not only to present evidence, but also know the claims of the opposing party and to respond to them. In the criminal context, due process also typically requires other procedural protections, such as an opportunity for confrontation and cross-examination of witnesses, discovery, and the opportunity to be represented by counsel. Which is pretty much exactly the exact opposite of what has been happening so far with Trump's deportation and rendition cases. Trump has publicly accused the detainees of being gang members, terrorists, or human traffickers, but many of the people who are being sent to the CICOT torture prison in El Salvador were never given an immigration hearing, let alone a full criminal trial with any of the above guaranteed rights. And by imprisoning people, citizens or immigrants, with no due process, the administration is violating their 5th Amendment rights. Now, sending an American citizen off to a Salvadoran torture prison would also likely be a violation of the Non-Detention Act. The Non-Detention Act was enacted to repeal a McCarthy-era statute that allowed the government to detain suspected subversives without due process. The Non-Detention Act requires an act of Congress for the executive to be able to detain a U.S. citizen without process. It states that, quote, no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress. But it seems like the Trump administration thinks it's found a way to get around the legal due process requirements anyway. It just has to remove someone from the United States fast enough and all their rights disappear like magic, because if you whisk someone away fast enough, the judicial system can't catch up. Now, the Trump administration isn't the first presidential administration to try this one weird trick. After the September 11th attacks, the George W. Bush administration set up offshore sites where accused terrorists were held. Some detainees were held as military combatants in CIA black sites in Europe and the Middle East. Others were held in Guantanamo Bay, Cuba. And typically, if someone, citizen or non-citizen, is being improperly detained by the government, the remedy for that is a habeas petition, which is a motion that asks the court to consider the legality of a person's detention. Jurisdiction for this typically lies in the place where the person is being held. Nonetheless, despite the fact that the detainees were being housed offshore, U.S. courts, including the Supreme Court, found that they had habeas corpus rights in U.S. courts. For example, in Rasool versus Bush, a group of Australian and Kuwaiti citizens who were being detained in Guantanamo challenged their detention with a habeas petition. The government argued that the detainees weren't actually within U.S. government control, so U.S. courts did not have jurisdiction. Now, the Bush administration pointed to the fact that the Guantanamo Bay land is not actually owned by the United States, it's leased from Cuba. So therefore, the Bush administration argued Cuba retained ultimate sovereignty over the land, so U.S. courts had no jurisdiction and couldn't hear habeas petitions from the prisoners being held there. But the U.S. Supreme Court disagreed, holding in a 6-3 decision that the degree of control exercised by the United States over the Guantanamo Bay base was sufficient to trigger the application of habeas corpus rights. The court also held that the right to habeas corpus is not dependent on citizenship status. And a related case, Hamdi versus Rumsfeld, which discussed the Non-Detention Act, actually did involve a US citizen. Yasir Hamdi was born in Louisiana and was captured in Afghanistan a few months after the September 11, 2001 attacks. The Bush administration first detained him in Guantanamo, then, after realizing he was a citizen, transferred him to a naval brig in Virginia, and later another naval brig in South Carolina. Hamdi's father filed suit on his behalf, arguing that his indefinite detention without trial was a violation of the Non-Detention Act, which again states that no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress. The Bush administration countered that the authorization for use of military force, the AUMF, passed after the September 11th attacks, met the Non-Detention Act standard for an act of Congress. And the Supreme Court agreed with the administration that the AUMF qualified as an act of Congress that satisfied the Non-Detention Act, but the court made it clear that Hamdi must be afforded at least some due process rights, and those rights could be somewhat relaxed given the ongoing war in Afghanistan, but even in the context of extreme wartime exigencies, detainees still had at least to be given some amount of due process, specifically the notice of the factual basis for their classification and a fair opportunity to rebut the government's factual assertions before a neutral decision maker. Writing for the court, Justice O'Connor stated, quote, "It is during our most challenging and uncertain moments that our nation's commitment to due process is most severely tested, and it is in those times that we must preserve our commitment at home to the principles for which we fight abroad." So even in the wartime context, which is relevant here because President Trump is claiming this is a foreign invasion, the government can't typically just suspend all due process and detain people, even terrorists, indefinitely without some kind of trial. But what if, in an uncharacteristic show of patience and restraint, the Trump administration actually allows US citizens to be convicted in a criminal trial with due process rights first? Then can it send people off to stay in a Salvadoran torture prison? Now, if you're not the US government and you're kidnapping people and sending them to a foreign country, you're gonna want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've got in a car crash, suffered a data breach, especially if you got a data breach letter saying that your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can maximize your recovery. By the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. Click below. Well, actually, this is a practice that was so common in the British sphere of influence that it actually has a name. It's called exile. And historically, exile, sometimes also called transport, was used as a tool to punish convicted criminals. In fact, Great Britain sent an estimated 50 to 120,000 criminals, political prisoners, and prisoners of war to the American colonies in the 1600s and 1700s. For obvious reasons, subjects of the crown weren't happy with this punishment. In fact, one of the grievances the founding fathers listed in the Declaration of Independence was the fact that King George III had, quote, transported us beyond seas to be tried for pretended offenses. Now, there are many reasons why transport was a particularly cruel punishment. It separated criminals from their families and communities so they could not even have visits. That separation also made it easier for their captors to engage in abusive practices. And though the sentences were often finite, they ended up effectively being life sentences because prisoners could often not afford to pay for a ticket back to their home once the prison terms had ended. But here in the United States, we don't send people abroad to serve prison sentences. At least, not yet. But the government has sent people to prisons that are still within the United States but are unreasonably far from home. In an effort to remedy that and other flaws in the criminal justice system, Congress passed the First Step Act, a bill that aimed to reduce recidivism, allow for inmates to earn sentence reductions, and improve prison conditions. Now, that bill was signed into law in 2018 by President Trump in his first term. And one of the provisions of the First Step Act specifically requires the Bureau of Prisons to house inmates in facilities that are as close to home as possible, preferably within 500 miles. So sending someone to a foreign country, any foreign country, would likely be a violation of the First Step Act, unless the Trump administration can make a strong case for why it can override the requirements in that legislation. But even if the administration can claim that there are security reasons or some other justification for why convicted US citizens cannot be kept close to home in keeping with the First Step Act, there are still serious constitutional problems with sending US criminals to be housed in other countries. Even the Bush administration, which took a famously dim view of civil liberties, knew this, which is why when it realized that Hamdi was a US citizen, it moved him out of Guantanamo and onto a brig in Virginia and then South Carolina. In a 2017 case called Doe versus Mattis, which I'll discuss more in a minute, the DC Circuit Court found that, quote, a fundamental attribute of United States citizenship is a right to remain in this country and to return after leaving. That right is implicated when the government seeks to forcibly transfer an American citizen from the United States to a foreign country. In Doe, the DC Circuit was considering whether a US citizen could be transferred to a third-party country or potentially be imprisoned there. The court ruled that forcible transfer to another country's custody would violate the fundamental attribute of citizenship. Customs and Border Protection's own website also cites the right to live in the United States as an inherent right of citizenship. CBP's website says, quote, a U.S. citizen's right to remain in the United States cannot be taken away. Now, many experts have argued that because the right to remain in the United States is an inherent right of citizenship, the only way for the Trump administration to force U.S. citizens out of the country, even temporarily, would be to strip those citizens of their citizenship. That would be an extraordinary, unprecedented action. But in the case of temporary confinement in a foreign country's prison, this is largely uncharted waters. And I'm sure the federal government would argue that if they maintain custody and control and merely subcontract out the prison terms of these inmates, that it would still qualify as U.S. soil or still qualify as remaining in the United States temporarily. And there's probably a spectrum of custody and control where it would be an open question. Again, these are uncharted territories that I don't think we want to be sailing in. Though spoiler, President Trump says he wants to do that too. But since we live in a timeline filled with extraordinary, unprecedented presidential actions, it's probably worth exploring in greater depth why the government can't just strip someone's citizenship away and force them out of the country. Now, the 14th Amendment of the U.S. Constitution states, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The 14th Amendment was enacted after the Civil War to address concerns about the rights of formerly enslaved people. The citizenship clause was included because in Dred Scott versus Sanford, the Supreme Court had held that enslaved people descended from Africans were not American citizens. The citizenship clause grants citizenship to everyone born in the United States, also known as birthright citizenship. And you guessed it, that provision is also being attacked by the Trump administration in the birthright citizenship executive order and the associated litigation. But courts have read the citizenship clause very broadly and only allowed for the removal of citizenship in very, very narrow circumstances. During World War II, Congress enacted the Nationality Act of 1940, which allowed citizenship to be stripped from anyone who served in a foreign military or government, if that person also had citizenship in that foreign country. It also mandated a loss of citizenship for people who deserted or evaded military service during wartime or who voted in a foreign election. But in Nishikawa versus Dulles, the provision calling for revocation of citizenship as a punishment for foreign military service was found to be unenforceable unless the government could prove that the service was voluntary. And the provision stripping citizenship for U.S. military deserters was considered in a case called Detroit versus Dulles. In that case, it involved a natural-born U.S. citizen who was convicted of deserting during World War II. The Supreme Court ruled that stripping someone of their citizenship as a punishment for a crime was a violation of the Eighth Amendment's prohibition on cruel and unusual punishment. Notably, Justice Earl Warren said that revoking citizenship is, quote, a form of punishment more primitive than torture, and it inflicts a total destruction of an individual's status in organized society. In Ephraim versus Rusk, the Supreme Court confirmed that a person cannot lose citizenship unless they choose to voluntarily give it up. In that case, the Supreme Court considered the case of Beas Ephraim, who had been born in Poland and naturalized as an American citizen, but had then voted in Israeli elections. The court struck down the provision of the Nationality Act of 1940 that allowed the government to strip citizenship from someone in retaliation for voting in a foreign election. Writing for the court, Justice Hugo Black concluded that, quote, once acquired, this 14th Amendment citizenship was not to be shifted, canceled, or diluted at the will of the federal government, the states, or any other governmental unit. Now, forcing someone out of the territory of the United States against their will would violate a statute that Trump himself signed into law and would infringe on a person's 14th Amendment rights as a citizen to remain in the United States. And it's likely that if President Trump sends them to CCOT specifically, that would add another constitutional violation and break the United States' promises as a signatory of the Convention Against Torture. Now, the human rights abuses in CCOT have been well documented in the various lawsuits against the Trump administration, and we've already discussed them in several of our videos about those lawsuits. But I think it's important to recount them briefly again, disturbing as they are, because the details bear directly on the question of whether or not it would be legal to send a U.S. citizen there. Now, credible news reports and independent investigations had documented numerous human rights violations in CCOT, including 153 inmate deaths in a one-year period, many of which could be attributed to torture, beating, strangulation, and lack of medical attention. Autopsies have revealed patterns of cuts, hematomas, sharp object wounds, and signs of strangulation, and survivors of the prison report being subjected to electrocution and untreated infections. The prison has no windows, fans, or air conditioning despite hot, humid, tropical conditions, and prisoners are housed in overcrowded cells and are denied access to reading materials, familial visits, exercise, healthcare, and outdoor time. The United States Department of State issued a lengthy report on President Bukele's human rights violations in 2022, and the Department of State found that, quote, significant human rights issues included credible reports of unlawful or arbitrary killings, forced disappearances, torture and cruel, inhuman, or degrading treatment or punishment by security forces, harsh and life-threatening prison conditions, arbitrary arrest and detention. Now, the Salvadoran prison conditions would almost certainly be violations of the 8th Amendment's prohibition on cruel and unusual punishment. The 8th Amendment reads, quote, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The Supreme Court has ruled that use of excessive force against prisoners violates the 8th Amendment. For example, in the case of Hudson versus McMillan, the Supreme Court ruled that force could be considered excessive even if the damage inflicted was minor. And from what we've heard about the injuries to prisoners in CCOT, their injuries are not minor. They are often life-threatening or even fatal. A 2024 report found that upon arrival in prison, detainees under the state of exception were, quote, beaten to pressure them to declare which gang they belonged to, and if they refused to say so, they were beaten and tortured more, some convulsed from the beatings they received, and others died in these practices on the first day of transfer. So it's hard to imagine a clear 8th Amendment violation. Now, overcrowding and resulting lack of medical care are also violations of the 8th Amendment's bar against cruel and unusual punishment. In Brown versus Plata, the Supreme Court actually mandated that the state of California reduce its prison population because the overcrowding was so severe. And as a result of the overcrowding in California's prisons, prisoners were unable to get mental or physical health care in a timely fashion, which the court affirmed amounted to an 8th Amendment violation. Now, credible reports have indicated that prisoners in CCOT live in overcrowded cells and suffer from untreated medical ailments. And according to Dr. Sarah Bishop's declaration in the JJG versus Trump Alien Enemies Act case, quote, an analysis of CCOT's design using satellite footage found that if the prison were to reach full supposed capacity of 40,000, each prisoner would have less than 2 feet of space in shared cells, an amount the authors point out is less than half the space required for transporting mid-sized cattle under EU law. And within that same declaration, Dr. Bishop recounted testimony from a doctor who had worked in the prison and reported that inmates were not provided with medication to treat their pre-existing conditions, and the guards often ignored pleas for help by sick inmates, which sometimes resulted in death. Now, that too would almost certainly be impermissible under the 8th Amendment. Now, the United States is also required to abide by the Conventions Against Torture. The Convention Against Torture states that, quote, no state party shall expel, return, or extradite a person to another state where there are substantial grounds for believing that he would be in danger of being subjected to torture. And there are ample grounds for the Trump administration to believe that torture is occurring in CCOT and other Salvadoran prisons. Human Rights Watch submitted a declaration in the JGG case detailing the abuses of Salvadoran prisons, including even the torture of children. And Amnesty International has also concluded that there is, quote, systemic use of torture in Salvadoran prisons. In 2022, our own Department of State found that there were credible reports that government officials engaged in torture. So again, it would be difficult for the Trump administration to claim that there aren't substantial grounds to believe that torture is occurring in Salvadoran prisons under Bukele's leadership. But what if, instead of doubling down on its agreement with Bukele, the administration decides to send American prisoners to some other less torture-filled prison outside of the United States? Would that be okay? Well, because of the 14th Amendment issues we've already talked about, this would likely not be allowed either. But there is one circumstance when the US government can send a US citizen to be imprisoned abroad, if there is a valid extradition treaty. In other words, if a US citizen commits a crime in another country and the United States has an extradition treaty with that country, then the US government may extradite its own citizen to that country in order to be tried under the other country's laws and potentially imprisoned there. But even in that instance, a US citizen must first be given a hearing within the US system to determine if there is sufficient factual evidence to support the other country's accusations. In Doe versus Mattis, the DC Circuit considered whether the first Trump administration could forcibly transfer an American citizen out of US military custody in Iraq to a third-party country. The unnamed plaintiff, Doe, was captured in Syrian territory controlled by the Islamic State and was then accused of being an enemy combatant working for the Islamic State. The Trump administration notified him that he was about to be transferred to the custody of a third-party country, and Doe, with the help of the ACLU, challenged this transfer. The DC Circuit relied on an earlier Supreme Court case, Valentine versus US, to find that even if someone has violated a law abroad, there is, quote, generally no executive discretion to surrender a person to a foreign government unless a statute or treaty confers the power. So unless someone is accused of a crime in a country where we have an extradition treaty, and they are given a proper hearing in which a US judge finds those accusations to be credible, the executive cannot simply ship a citizen off to another country, even if that country doesn't host torture prisons. But given the Trump administration's track record here, we don't expect that they're going to let minor things like statutes or the US Constitution stop them. And what about the deported US citizen children? Well, for one, initials VML, the federal court in Louisiana, and remember this is Judge Doughty, a very, very Trump-friendly judge, and you can tell this by some of the language that's being used in this particular order. He said, quote, before the court is a petition for writ of habeas corpus, an emergency motion for temporary restraining order filed on behalf of VML. VML is ostensibly a 2-year-old United States citizen. On April 24th, 2025, this court received a petition contending that VML was being deported alongside her illegal immigrant mother to Honduras. Of course, it is illegal and unconstitutional to deport, detain for deportation, or recommend deportation of a U.S. citizen, citing several cases affirming that a citizen has the absolute right to enter the United States borders, And citing another case, this court long ago recognized that the nature of our federal union and our constitutional concepts of personal liberty unite to require that all citizens be free to travel throughout the length and breadth of our land uninhibited by statutes, rules, or regulations which unreasonably burden or restrict this movement. The government contends that this is all okay because the mother wishes that the child be deported with her. But the court doesn't know that. Seeking the path of least resistance, the court called counsel for the government at 12:19 p.m. CST so that we could speak with VML's mother and survey her consent and custodial rights. The court was independently aware at the time that the plane, tail number N570TA, was above the Gulf of America. The court was then called back by counsel for the government at 1:06 p.m. CST, informing the court that a call with VML's mother would not be possible because she, and presumably VML, had just been released in Honduras. In the interest of dispelling our strong suspicion that the government just deported a U.S. citizen with no meaningful process, it is ordered that this matter be set for hearing at 9 a.m. on May 16, 2025. So I guess check back in 3 weeks. Now, if you do get renditioned off to a foreign country, the last thing you want, or maybe the second last thing that you want after getting sent to a torture gulag, is getting hit with a whole bunch of roaming fees on your cell phone, which you can avoid with today's sponsor, Saley. Saley is the best way to get high-speed data on your cell phone whenever you travel abroad or travel to places in the country without safe and secure Wi-Fi. Saley is an incredible new eSIM service app from your friends at Nord Security, so you know it's quality. It's a great alternative to buying a local SIM card because it works in 160 countries across 8 global regions, and clicking on the link or using my code LegalEagle will get you an exclusive 15% off discount of your first purchase. Now, if you've ever been lost abroad, whether you got renditioned or not, or only have access to sketchy public Wi-Fi that could steal your data, you'll understand what a difference a local SIM card can make. An eSIM provides you a secure internet connection whenever you travel, saving you tons of money on roaming fees and data overages. And by using a Saley eSIM, you never have to remember that all the photos and videos that you're going to take on vacation and now quietly uploading in the background, blowing up your data allowance and costing a fortune. Not that I have ever made that mistake. And with the Saley app, getting an eSIM for your iOS or Android device couldn't be simpler. You just buy a plan and activate it, all in the Saley app or on the website. And once you've got it activated, you're good to use the internet wherever you go without needing to pop into a cafe and pray that they have decent Wi-Fi with at least some security. And an eSIM with Saley saves you tons of time when it matters most. There's no need to wait in line at every airport to get a local physical SIM card because a Saley eSIM is entirely virtual. It just works. So click on the link below or use the code LegalEagle to get an exclusive 15% off your first purchase. A Saley eSIM really is a traveler's best friend and is the best decision you can make before going to another country. So click on the link below and get 15% off. And then after that, click on this video over here for more LegalEagle, or I'll see you in court.